here on Instagram as well.
Oh, you're on your screen. Just letting you know, it's live now.
Yes.
It says that everything's live.
Awesome. Hey guys.
Hi everyone.
Hi
Let us
folks.
know.
We have. Sorry, what did you say, Nicole?
I'm like, I was just telling people, let us know if you can't hear us for whatever reason.
Yes, please tell us, because we are streaming this on many platforms. So we're going to expect many questions. And the goal is to get through as many as possible. So if you can hear us, please give us a yes in the chat box. Hi, everyone. This is Soundarya. We have Nicole Gunara with us. If you can hear us, give us a yes in the comment section, wherever you're at. Thanks so much, Nikhil and Shalini. I see you guys have given us yes. Perfect. Lovely. We'll just wait for another minute or two, and then we'll get started.
For sure.
Thanks to everyone giving a yes. Really helps. And I also wanted to ask you all, can you let us know what is your current visa type? I'm trying to figure out, do we have a lot of students joining? Is it people on H1B already? Or is it someone else entirely, like someone who's outside the country? So let us know in the chat box, what is your current status, if you are comfortable sharing that. So to everyone who just joined, what is your current status? Meaning, are you on an F1 OPT, STEM, H4, H1B? Fantastic. I'm seeing a split between F1 and H1B. A few H4s here and there. Gotcha. Oh, starting my study next spring. Wow. You are extremely proactive. Good for you. Lovely. Lovely. To everyone who just joined, we're going to spend the next hour talking about the following things. I also want to show you kind of who we're going to be talking to, as well as the 4 topics that we'll be covering throughout the next 60 minutes. So we have Nicole Gunara. She's a principal attorney at Manifest Law. You can see on the screen. I've done a webinar with Nicole in the past. She is absolutely amazing because she is very clear and to the point and honest in responding to your questions. Nicole, thank you for joining us. Hi.
Thank you for having me, and also wonderful to see everyone here. I know that it could be in very different circumstances, but I'm really happy to be here to answer as much as I can, because I know that a lot of this news is very distressing, a lot to kind of go through, and a little bit confusing. So hopefully everyone gets some level of clarity in talking to me today.
Absolutely. The past 2 days have been pretty chaotic, and for some people, a lot of money was lost in the last few days because of booking last-minute tickets, because of deciding to not take a flight. I know someone who told me that they canceled a travel plan they had because they thought they may not be able to enter back. So it did disrupt people's lives. And so the point of this webinar is to give you, number one, a timeline of the last 2 days. So you know exactly what happened and where we're at right now, number one. Second is we'll talk about who does this rule affect and who does this not affect. And I have a feeling many of you on this call, it doesn't affect you. So we want to make sure you know that. Third, we'll talk about alternatives. Like, what can you look at besides the H1B if you're currently on an F1 OPT or if you haven't even started your education? And finally, we'll answer any other alternative questions that come up from people like who are on H4, L1, etc. So once again, we'll talk about timeline. We will talk about who the rule affects and who it does not affect, alternatives, and finally answer any other questions outside of these. So ask your question when we get to those topics, because then we can try to make sure everyone's questions answered. Lovely. So we'll start with timeline. And Nicole, let us know what happened the last 48 hours.
So much has happened, right? But I'm going to do like a really quick run through of everything, which is that on September 19th, last Friday, we get this like news report from Bloomberg that says, hey, the Trump administration is going to announce this whole $100,000 fee that's going to be imposed to everyone who does an H1B, right? So that's like the general thread. Then the administration does like a live stream where they talk about the proclamation, they answer a few questions, and then they sign it. And in answering those questions, it creates like a lot of confusion because a lot of the questions were like, is it annual? Does it apply to everyone? And a lot of the answers are like, yes, it does apply to everyone. It's going to be a renewal, all these kinds of things. Then like several hours after the signing, they finally dropped the actual contents of the proclamation, like the written statement of what it is. And that is when a lot of the chaos truly unfolded. Why? Because we saw the dates that were involved. They basically said beginning September 21st, 12:01 a.m. EDT, this is going to impact any H1B petition. Anyone who's trying to come in on an H1B and needs to prove that they have paid this $100,000 fee, with very minimal exceptions that were listed. So right after that, or a day after kind of the chaos and people are trying to get off planes, I saw like social media videos of people literally arguing with airline stewardesses saying like, get me off this plane. I am not leaving right now. I am going to stay in America. A day after, the White House press decides to clarify a few points. And I would assume it's because there's a lot of pressure. A lot of press correspondents were probably reaching out to the White House being like, you need to clarify all this stuff because we have no idea how this impacts anybody. Right. So the press secretary and the rapid response team on behalf of POTUS decides to express to the government that, or to the rest of us here, like, this is the clarification. So they write 3 clarifying points about how it doesn't impact anyone who already has an approved visa, anyone who needs a renewal. It's only going to starting the next lottery. That's basically the statement that was made by the press secretary and the rapid response team. But then later that evening, USCIS and CBP issued their own guidances related to it. And these guidances actually made it a little bit more confusing because they weren't 100% aligned with what the press secretary said and what the rapid response team said, because they made references again to this September 21st, 12:01 a.m. EDT cutoff time that wasn't really referenced by the press secretary. So after these policy guidances were issued, essentially September 21st rolled around, the policy technically takes effect, right? There is still uncertainty that continues on when it comes to how does it impact renewals? How does it impact extensions? What are the exemptions? What about the lottery? Right? And then on or about September 21st, USCIS actually publishes these H1B FAQs, which again were aimed to provide more clarity, but actually sowed even more confusion because of the type of wording that was used for it, right? Specifically the terms related to what counts as an H1B renewal that doesn't have any applicability under the proclamation. So essentially, overall timeline is that there was a proclamation, there was that written statement, there were a bunch of Twitter or X posts that were done from the press secretary and the president's team. Alongside that, there were some USCIS and CBP guidance issuances. And then on top of it, we see here that there's also an FAQ update that isn't really exactly what the guidances had actually said. So now we're in this room of confusion together.
Okay. So I think we can skip these because I actually really want to get to answering some of the questions I'm already seeing. First, can you tell people who do not need to worry? Like, who are the sets of people who can really just leave the webinar right now, even if they want to, because they don't have to worry about this?
So there's 3 primary buckets of individuals that were clearly listed in both the CBP guidance and in the USCIS guidance as being at least safe for now. That's what I want to be clear about. And it's individuals who, one, had a pending application prior to September 21st of 2025 at 12:01 a.m. EDT. So if you have a pending application, they're not going to come back to you and say you need to pay this 100K fee. It was already pending before that point. The second item is for anybody who has a currently valid approved petition from prior to September 21st, 2025 at 12:01 a.m. EDT. And then the third bucket is for individuals who have a currently approved valid H1B visa. And I think in this case, they're really referencing the passport stamp, the stamp that you get if you have an H1B visa stamping completed abroad. So those are the three buckets of individuals that clearly and also anecdotally have been able to enter the United States even after that cutoff date without too much of an issue or explanation. But it's everything outside of that that really is still quite unclear, right? What if you need to do a renewal afterwards? What if you need to do an extension afterwards? What if after September 21st of 2025, you were about to file an H1B Cap-exempt or a change of employer application? What happens in that scenario, even if you don't travel? That, to some degree, is up in the air because of the conflicts between the guidances. And we're going to kind of break that down a little bit further later on. Okay. The other thing that is also not clear is the scope of national interest exceptions. They said that the secretary can say these exceptions, but we'll kind of unpack that together, Soundarya.
Yeah. I think there's a lot. Even I'm feeling overwhelmed, and I'm someone who, understands this slightly more than the average person. I'm going to repeat again, the people who are not impacted by this, those who have a pending H1B application before September 21st, those who have an approved application, meaning they were already on the H1B, they are on the H1B right now, they're not impacted, and those who have a valid H1B visa stamp, I guess that's a variation of the second. So these guys Correct. Don't have to worry. Mm-hmm. What about people who are trying to, I'm sorry?
That's according to the guidances that are out right now.
As of now, yeah. Everything we're saying, by the way, to those watching is as of this moment. It could change. What about people who are renewing their H1B in the coming years and people who are transferring to a different employer?
So here's the thing, is that the USCIS FAQs that were published most recently said that if you are doing an H1B renewal, you shouldn't be impacted, or this proclamation doesn't apply to you. There's no fee. However, I think all of us here who've seen an I-129 form, I'm sitting here thinking, what is the definition of an H1B renewal, right? Is it that the H1B renewal that is exempted from all of this, one where you're staying with the same employer and you're seeking an extension of status? Or what if you're doing a change of employer application? And then in that case, you're also seeking an extension because you might as well when you're asking for it. But what about the third scenario where you did 2 years on an H1B, you left the country to go finish a master's program in London, right? And then you found your dream job at a company like Meta, and they're like, hey, you have 4 years remaining on your H1B. Let me recapture or utilize that remaining time that you have on your H1B to bring you back to the US. Is that technically a renewal as well? So when I hear the term H1B renewal, I think to myself, can they clarify it? What about in these three situations? The most conservative perspective is that a renewal is something that you are renewing with the same company under the same status. But what about everything else that I just discussed? Filing a transfer act?
Okay. What you're saying is if you're renewing an H1B within the same company, you're not impacted. You do not have to worry.
Okay. That's the conservative interpretation right now, for sure.
Renewals on H1B are not impacted within the same company. Are you saying that it is unclear whether if you transfer to a different company, you have to pay, or you're saying you're not impacted?
I'm saying that it's unclear. Because I know that some people are going to point to, well, the CBP guidance says, right, that if you're in the country and you're not traveling out of the country, then it's fine. But that's not how USCIS wrote their guidance and their FAQs. They don't really make any mention of that distinguishment. And the other thing that people are not kind of noticing is at the end of the day, these are all guidances, right? But What about what was written in the actual proclamation? The directive that was given to the DHS, to all the relevant stakeholders to action, right? Versus also people are citing to what the press secretary said about how it doesn't impact people who are transferring or certain kind of visa holders. And I'm like, again, are we going to cite to the social media post, or are we going to take a look at the actual proclamation itself or the FAQs, right? So there's just a lot of confusion right now.
So, okay, that's not helpful for, I think, a lot of people who are listening to this in terms of, it's sadly still unclear is what we're saying, is that if you're renewing within your company, you should be fine. But if you're transferring to a different company or, okay, let's just talk about that. Transferring to a different company, it's unclear because the press secretary's tweet sounds like you should not be impacted, but USCIS's language is not very clear on that. So it's still a maybe. Okay.
It's still a maybe.
So for anyone who's listening, who's thinking of transferring an H1B to a new employer, it's unclear right now. I mean, we want to believe that you would not be impacted. And I think we'll know in the coming few weeks. Like, when do you think we'd know more about this? For sure.
I will say that there is a lot of pressure on the government right now to continue clarifying. And that's the reason why every single day we're getting more and more publications and the like. I can't tell you exactly when, but one thing that I do know is that there's a lot of litigation that's going to be coming through probably this week or the next. And I think that's going to unearth a lot during this time. So.
Right. Okay. I'm seeing so many questions that I can't even keep track of them. I'm trying to see if I can pick one of them that would apply to a lot of people. Let's pick Rashmi's question. Rashmi asks, what about an F1 student applying in the next year's H1B lottery in 2026? Would they be impacted? If so, how?
So that is the one thing that I know is very clear from the current situation, is that you will be impacted for this upcoming lottery cycle for March of 2026. Because that's clearly a new petition, and multiple references across the guidances say that it will start or it will impact that lottery cycle. So assume that if you enter the lottery for next year and you win, that the petition will charge that supplemental $100,000 fee.
I mean, that's really, it sucks. Like, there's no other way to say that. It's so disheartening for people to hear that. If I was applying as a student, I would think, what employer would be willing to pay that kind of fee to get me on board? So I'm curious, do you think there is a chance that it may not apply? Like, one is litigation. It goes to court. And so actually walk us through that. It goes to court, and then what happens there?
So essentially, like when you're talking about litigation, I can see something known as a class action lawsuit, where like a whole group of people who are victims of a shared kind of scenario essentially decide to sue the government over this entire situation. And as part of that lawsuit, they can ask a judge to essentially issue something known as a TRO, or a temporary restraining order. The temporary restraining order would basically tell the US government that you cannot implement this new policy because it needs to be litigated first to determine whether or not it's rightful for them to do this, because the impact of leaving it as is going to be too strong and would be difficult to overcome and roll back. So a TRO would effectively stay or prevent this implementation to come immediately. Think of it as similar to like the birthright citizenship stuff, right? Where there was this kind of continued extension of when these things are actually going to come into place. So that's what it would look like in the case.
Okay. So just to like summarize that, a temporary injunction order would pause this from taking effect. And it sounds like there's a good chance that it will be taken to court. I mean, I haven't seen any news article just yet, but do you think it's going to happen soon?
I think it's going to happen. I think the immigration legal industry is quite small, right? I think there's only like 50,000 of us lawyers out there, and there's already a lot of conversations. Some of the largest kind of, let's call it funds or groups of individuals who do a lot of these litigative efforts are already putting it all together, and they seem very confident that there's going to be some sort of litigative effort.
Okay. On this note, before I move on to change of status and cap-exempt H1B, I want to ask, some people are saying only the people who apply for 2026 lottery from outside the US should be impacted by this based on the language, and not the people who are inside who apply for change of status, so they don't even have to leave the country. What do you think about that?
I have a tendency to disagree because I do run conservatively. And the reason why I run conservatively is because it actually protects you the most to interpret. Because I cannot, if I interpret it very liberally and say that all of the guidances, or if I pick and choose which guidances I want to follow, then you could leave yourself unprotected. All I can say is really take a look at the H1B FAQ that was published by USCIS and look at the way that they wrote that FAQ. That FAQ doesn't distinguish between individuals out of the country or in the country. The FAQ, it's actually, it's right here. It basically just says, and I quote, right, any other H1B petition submitted after 12:01 a.m. Eastern Daylight Time on September 21, 2025. And then when it says the proclamation does not impact, it doesn't have anyone that says or anything related to if you're in the country or if you're out of the country.
Okay. So the USCIS FAQ, I can see that myself. As you all can see, if it's too small, I'll read this out for you guys. It says, the proclamation requires a $100,000 payment to accompany any new H-1B visa petitions submitted after 12 a.m. Eastern, September 21st, 2025. This includes the 2026 lottery and any other H-1B petition submitted after the so-and-so time. Some people are asking, hey, I didn't get chosen in this year's lottery. So would it be considered a new petition if I file next year? It would be, correct? Because you weren't chosen in this year's lottery. Yes. So let's talk about cap-exempt H1B. People who do not go through a lottery, how are they impacted? Is it the same as the cap subject H1B?
Yeah, I mean, I will say one thing. There was a Reuters publication that came out today that said that it seems like there could be exemptions for physicians, and some physicians qualify for cap exempt. But as of right now, I have not seen a statement on how it directly impacts cap exempt if there are going to be exceptions. Instead, it's that if you look at the proclamation and what it's citing to, it is inclusive of those H-1B petitions as well.
Yeah. I want to talk about actually, before even we go to alternatives, can you talk about, some lawyers were telling me, hey, the proclamation has this arbitrary language that exceptions will be made or can be made for people who are, say, doctors and nurses who are necessary for the country. Is that true, first of all?
So there is a carve out, like the government put into the proclamation this section that says that the Secretary of Homeland Security can designate industries or designate companies that would be exempted from this H-1B for national interest or national benefit, right? Or for the benefit of national security. And it reminds me very similar to the language that was in place for NIEs. If you guys remember during COVID, when people used to apply for national interest exceptions to get the visas to come to the United States during the pandemic. As of right now, there hasn't been anything published that says, what those exemptions are going to be and in what industries. I can only surmise that there's going to be some sort of list at some point, because for them to include that carve out means that there's some level of intention related to it.
Yes. To summarize, once again, you're saying that there's a good chance they'll publish a list of people who are exempted from the fee altogether, people who are necessary for this country. So but we could expect that.
Yeah.
It hasn't been published yet. I'm seeing, once again, repeat questions from people like Sahil and Priyank asking, hey, I already have an approved petition. I'm going for stamping. Will I be affected? I want to repeat for all of you that if you have, once again, see this, if you already have a previously issued H-1B visa or an approval or a the fact that you were picked in the lottery, this does not impact you. Is that right, Nicole?
That is correct. That is the one thing I can say is like very clear.
Okay, good. And what about students? Some people are asking, you wrote here that somewhere on the slides you said international travel, avoid international travel until clarified. Do people still have to avoid this for some reason?
I just feel like we should be treating travel as a luxury, right? Unless you're in those three buckets that we mentioned earlier, I really think that travel should just be avoided if it's non-essential. And the reason has to do with the fact that when you're in the United States, you're in the most defensible position. It's one thing for USCIS to try to go after you, to basically said, hey, I'm going to maybe revoke your visa or try to remove you from the country and all these kinds of things. Because here in the United States, under USCIS, you have opportunities to rebut. You have opportunities to argue against them, to appeal, right? But when you're outside of the United States, those mechanisms stop to exist. Who can you go to appeal a consular process, right? Maybe there's something called LegalNet, but there isn't really a mechanism to say, hey, the consular officer messed up my application, right? The second thing that I can also say is that if you're outside of the country and you try to enter, when you try to enter passport control through Customs and Border Protection, there's nothing you can do if the officer decides that, hey, this rule applies to you, I don't see it, I'm going to turn you around. It's not like you can call somebody or do an appeal there. So that's the reason why I tell people it's always better to be in the United States than outside of the United States, because when you're in the United States, you're in the most protected position possible because there are mechanisms to appeal and change things and counter argue.
I just, once again, it sucks. But on that note, before we move on to, there's a lot of people asking, what about if I transfer from H4, B2 and other visas to H1B? One last question on travel. What if I'm on an O1, for example? There are people on STEM OPT and OPT. Is there any reason that people like us should not be traveling right now? Like, I understand you're saying you're taking the most conservative approach. But is there a reason for people like us who are not on H1Bs to also not travel?
Outside of what I said earlier, which is that the most defensible position is to always be in the United States. It's just that what I've noticed from the language and let's call it the rhetoric, right, from the Commerce Secretary, Stephen Lutnick and the like, is that they are trying to provide a lot of changes to immigration policy in the next coming months. I cannot guarantee to you that in a week from now or 2 weeks from now or even a month from now, that they aren't going to be changing the O1, that they aren't going to be changing STEM OPT and OPT, right? So the only thing that I can tell people is that when you have a tumultuous year like this one, where there's a sudden change of administration that has a very different perspective of how immigration is done, then yeah, I do run conservatively because the only thing I can do to defend you is to be here in the United States.
Okay, so it sounds like, I want to just, for everyone thinking about traveling, it's more of, in an ideal world, there should be no impact because you have a valid visa, you should be able to enter. And this year has been not ideal because of what's happened. So treat travel as a luxury. That's what you're saying.
100%. It's like the question of do I take 0% risk or do I take a 5% risk or a 20% risk? It kind of just depends.
Let's talk about visas like H4 and B2. So people who are on H4, B2, L1, and so on, doing a change of status to H1B. So will they be impacted as well? According to this FAQ, it sounds like yes, because it's still a new petition. Is that right?
Yeah, that's honestly how I feel, right? Because there isn't a clear definition of what a renewal is. I think earlier I expressed an example of what if I do come back onto an H1B? What if I try to change back into an H1B? Is that considered new employment? Yes or no, right? I think it's so hard, even in my position as a practitioner, to say if it's going to apply to you or not, but I have to take the words of USCIS at the moment and the way that they've really written it here. I think we all are seeing it on this screen right now.
Yeah. So for anyone who's asking, hey, what if I do a transfer from H4 to this, L1 to this, B1 to this, B2 to this? The answer is Yes, because it's still considered a new H1B petition. And, even if I'm on H4 and I transition to H1B, I still have to be chosen in the lottery or get a cap-exempt H1B, correct? So it's
That is
still,
correct.
yeah, it
Yeah.
doesn't really make a difference. Sounds good. I'm just seeing if I want to reiterate, people are asking again, if I already have an approved H1B, will I be impacted? You will not be impacted if you already have an approved H1B. Kenny asks, will the rule affect people who apply to H1B for the first time in the US and have an approved I-140? Thanks.
So I think that when people bring in like the question of an approved I-140, their whole thing is that does it somehow exempt me from this situation? Because now I
Actually,
don't.
what is the I-140? Maybe you explain that for those who don't know.
So an I-140 is a form that's approved if you've proven your eligibility for a green card. Traditionally, the reason why you have an I-140 is either, hey, you successfully argued that you qualify for an EB1A, or your employer sponsored you for a green card and finished the perm process. And the reason why so many people on H1B have an I-140 is because it allows you to extend your H1B beyond the 6-year limit that is usually imposed on the H1B. So a lot of the reasons why we get questions surrounding I-140s when it comes to this news is that there's this general sentiment of, well, if I have an approved I-140, does this even apply to me, right? Does me extending or me asking for that new 3 years beyond the 6-year limit mean that I need to pay this 100K, yes or no? And the answer to that question is that nothing in the proclamation exempts you, even if you have an approved I-140. And a lot of the confusion stems from the language of like national interest and all this kind of stuff, because let's say you have an approved EB2 and NIW. That's how you get an I-140. Technically, the government has affirmed that I am doing something of national interest. Does that mean I'm going to have an exception because the Secretary of Homeland Security is going to say so? No. As of the way that it's written, if I'm asking for an H1B, depending on how you define renewal, I guess moving forward, it could apply to you.
Okay. So you're saying that at least the FAQ does not say clearly that I-140, folks who have I-140 approved are exempted from this.
Correct.
Once again, a reminder to everyone is there is a very good possibility, or a possibility, I shouldn't say anything, that they'll publish a list of people who are exempted from the fee altogether. And this could include people whose work is in the national interest in terms of doctors, nurses, and maybe people who have an NIW approved or an EB1A approved. Who knows? So as of now, the answer is we don't know.
Yeah, I know. And I wish I had clearer answers, because I can see a lot of the comments are like, but Nicole, this is what CBP in the US memorandum says. It mentions the entry of aliens outside of the country, and that's what the proclamation says as well. But what words do we take? Right? Like, what parts of everything that has been released do we take as truth? Right? Because to me, I know for many of you who are here, like, I really want to express, I'm taking the path of conservatism, right? I have to take out of everything that has been written, what is the worst case scenario? Because when I take that worst case scenario, you're in the best position possible. And we're reading the same thing together. This is what they're publishing on the USCIS website as their FAQ, to try to clarify something that they kind of made a little bit more confusing.
One more interesting question is people who got laid off. I'm seeing quite a few comments of people who were on H1Bs, got laid off, switched to a B2 visa or a B1 visa, and now maybe want to switch back to an H1B. So by that logic, they already have a previously issued H1B. Would they be impacted? Is it clear that they will not be impacted, or is it like a gray area?
I think it's a gray area because, and maybe I'm pedantic, right? Maybe for all of you guys, I'm a little bit picky with words, right? But let's talk about what a visa is, right? A visa is not that green piece of paper that is an approval notice, right? A visa is technically the stamp that's in your passport. So like, that's the reason why when I'm looking at this language, it's just very, very confusing. And like, even if you look at the USCIS guidance, the actual policy memorandum, they say currently valid approved petition. I believe that that's what they wrote, right? So if you're laid off from a company, like you're laid off from a job, is that still a valid approved petition? Is it? Because usually, functionally, having been a lawyer that represents like companies, right? The moment that someone is terminated, we file to withdraw that application. Remember like the whole scenario a few months ago where a lot of H1B holders were getting NTA. They were asked to come to court, right? Because they were on their 60-day grace period, but they got a revocation notice because their previous H1Bs were revoked because they were withdrawn. So what does that mean, right? Does that count? Does that mean that you were have a currently valid approved notice, yes or no? So I think that's, again, where there's so many areas of confusion, Soundarya. I wish that I could make this so much simpler, but there's so many areas and rooms of interpretation because nomenclature and words really matter. And I feel like there's a lot of random words being selected here for usage.
Yeah. Yeah, I want to summarize the discussion so far for people. The people who are absolutely not affected, at least so far, are people who have an H1B approved, are currently on the H1B and working at a company. The people who are renewing an H1B within the same company in the coming years, and the people who got picked in this year's lottery and they're going to switch to an H1B from October 1st. Am I correct there?
That is correct.
If you are in any of these categories, I'm happy that you're not impacted and you can drop off the webinar unless you're interested in the O1 visa. If yes, stay back. The rest of you, honestly, I would say, like, don't be disheartened, though. There is a good chance things will get blocked in court or that they'll make exceptions in the coming weeks and months. So I would just say, like, assume worst case scenario. But then, if the best case scenario happens, awesome. You can go celebrate with your friends. So, Nicole, one last question before we move on to the O1 as an alternative and the J1 as an alternative. Someone asked something about FOIA, which is interesting. FOIA is the Freedom of, I forget the full form. What is FOIA? Freedom of Information Act. Yes. So someone's asking, can the lawyers file a FOIA to get more clarity on all these questions, which they should have already clarified?
They can, but the question of how quickly we'll get that FOIA is another answer. Just to let you know, when they give us a FOIA, they actually send us back a CD-ROM. So I don't know the last time any of us had a disk drive.
Wow.
So the reality is that it takes time to collect a lot of those items. And I think by the time we get those items back, we might already have more clarity through other means, whether it's through litigation or whether it's through further policy guidance as each day kind of rolls on by.
Gotcha. Okay. So FOIA, not as helpful because it takes time. Like it takes 6 months sometimes. Cool. Once again, I'm seeing a lot of repeat questions. I just want to emphasize, anyone who's on F1 OPT, STEM OPT, H4, B2, L1 outside the country, and you're all thinking of filing an H1B next year, you could be impacted. However, we'll know more in the coming weeks and months. In a way, like I think it's the not knowing that's so frustrating. If they came and said, you will absolutely be impacted if you're in this category, even that's better. At least I know that I will be impacted. I'll prepare for worst case. Now it's like, I have to prepare for worst case, but also in 3 months, maybe I'm not impacted at all. And I don't think that's the worst thing in the world. I actually think preparing towards an O1 is good for your career. It certainly was in my case. So with that in mind, is there anything else you want to say before we move on to alternatives?
I think a lot of viewers are kind of confused because they'll say, other lawyers have said certain things, or like some of the guidance have said certain things. Like, I really want to emphasize that when there's this level of confusion, when there's this level of guidances that are out there, there's a lot of room for interpretation, right? And that's an attorney's job, is to interpret the information that is out there. And the truth is always somewhere in the middle, or someone is right or someone is wrong, right? It's just right now, all of this is very new. There's a lot of conflicting guidance. And I think, Soundarya, you and I having sat here, you can see the words are all kind of jumbled. They're all changing between every single slide. So what is it? So for many of you who are saying like, hey, can I really get some clarity? Trust me, I'm looking for that clarity just as much as you are. I am waiting for one day a chart to be published that says, hey, if this is your scenario, this applies to you, or this is the definition of what is considered counts under the proclamation or what doesn't count. And we're all honestly, as attorneys, waiting for that. My expectation, Soundarya, is that they're going to release a new form. They're going to release a new I-29 form, and that new form will give us a lot of insight into whether or not somebody has to pay that $100,000. Because with that new form is new instructions.
Okay, that's good. All right. So for everyone who's listening, who's not on an H1B right now, once again, I'm not talking about people who applied this year. You are fine if you applied and got picked. I'm talking about people who have never applied for an H1. Assume worst case scenario. Once again, we are taking the most conservative approach on this call. So, like I always say, when you hear something, hear it through the lens of why the person is saying that. Like, where is that coming from? Nicole is taking the most conservative stance on this call, just so that you're all protected. With that in mind, here are the alternatives that you can look at starting now itself. First is the J1 specialist or research scholar program. So I think the J1, almost no one knows about this. Even I didn't know about this until recently. So yeah, who is this eligible for?
So the J1 is actually eligible for a wide variety of individuals, and it depends on whether you walk down the path of the J1 specialist or the J1 research scholar. So many of you guys probably have heard of the J1 before. You might have heard about it as an intern or a trainee, right? I'm coming to the United States to intern or train under a company. You might have also heard about it for summer work travel. If you've ever gone to a ski mountain, a lot of people are working there during what they call the summer or like the winter period in order to gain like 3 months of experience or work. But there are a lot of underutilized J1 programs that are out there that many of you don't know. I'm going to talk first about the specialist program, which is shorter, but something that is most widely applicable, which is that a private company can sponsor, and you can actually pay for it. It's unlike the H1B, which doesn't allow you to pay for it. On a J1, you can pay for the fees associated with it. Essentially, you are saying that you are an expert with specialized knowledge or skills, whether it's through your academic pursuits or your experience, and that you're coming to work for a U.S. institution for at least 1 year, but you can garner more years by exiting and technically renewing it or getting a new 1 year period, to focus on training people in the US, knowledge sharing with the US, and providing a professional exchange. To give you an example, if I'm an engineer and I know a lot about designing windmills and I have a lot of expertise in doing it, I can come to the United States to share that information, to impart that information, or to impart my professional skill set to a US institution or a US company, which is functionally what you do when you're designing those windmills anyway. For the J1 Research Scholar Program, it's actually much more powerful for people who are in STEM-oriented fields working for STEM-oriented companies. So many of you may have heard of a research scholar before, and you're thinking to yourself, Nicole, isn't that only for university and like college researchers, right? Those scholars who are working in laboratories or maybe kind of going to some level of schooling? The answer is no. The Research Scholar Program is actually eligible for people who are working for private companies. And it's actually approvable for up to 5 years, which is an extensive period of time. And it's one filing to get to 5 years, right? And the reality is that spouses can also work. You can apply to get work authorizations for spouses, and that's for both J1 programs. So how is it that somebody can qualify for a research scholar program? You have to just express that you are someone who is qualified to provide your expertise to contribute or conduct or consult on research or collaborative, innovative professional projects. So let's take my engineer example from before. If I am an engineer who knows how to design the brand new or most innovative windmills to capture wind power that is so massive or beneficial to the United States in some form or way, but I'm doing it for like a private company. Let's just make up a company. Let's say Nike decided to invest in windmills, right? Then there is a reasonable argument to make to the government that you are a research scholar. I am doing this engineering and designing work for this company, Nike, that decided to invest into windmills for their initiatives. And there is no requirement to have published research or original research. It's just that you are conducting research as part of that let's call it program or that initiative or project that you are doing over that 5-year period. Some of you may be mentioning something known as a 2-year foreign residency requirement. You might have heard that certain J1s, after the end of their program, they have to go home for at least 2 years before they can come back to the United States. That is not really the case. The 2-year home for residency rule applies only if it's triggered. And for example, it's usually triggered through something known as the country skills list. There was a time that India was on this list, and that's a reason why a lot of people didn't utilize this program. But take a look at the list now. That changed significantly at the end of last year. And this is a powerful visa because there's no lottery. There's no, let's call it that cap, like there's no lottery process. It can be applied for at any time so long as you qualify. And it's a quick process. You're looking at about 4 to 6 weeks, maybe 8 weeks, depending on which like agency you go with to do it. And you can pay for it yourself. You can try to convince your employer like, hey, you can give me the salary, but I will pay for the agency fees and the process on my own. I will hire the attorney on my own, which is a very powerful tool for some of the smaller companies that may not be as familiar with immigration.
Okay. I'm giving people, I think we need to summarize this because I heard a few things that even I didn't know for the first time. For everyone who's listening at this moment, we are talking about alternatives to the H1B that you can consider starting today. We are not talking about the rule anymore. We'll publish the recording of the webinar, so watch the first 40 minutes where we talked about this extensively. So the J1, I'm going to summarize again. It's not only for researchers, like people who are doing PhDs. It's also for people who do research as part of their job for a private company like Amazon. Let's take Amazon because Amazon files the most number of H1Bs of all the big tech companies. I am a software engineer at Amazon, which is something that a lot of our audience probably would be. Could I use the J1 route in some way?
Yeah, it could be through the specialist program, but let's say we decided to focus on research scholars because you get that huge bandwidth of time, right? If you're doing something cool for, let's say it's AWS, right, which somewhat tangentially is associated with Amazon, right? And you're developing what is the latest and greatest of like what cloud architecture can look like. What if it's multiple structures that are involved or ways that these two systems can communicate with each other? That's innovative. And to do those innovations requires you to do some level of research about how these things can interact. Like it's actually quite expansive. And it's not that it's super easy. Like no matter what, an attorney needs to be able to make that argument. But the moment that you start thinking about innovation, I think all of you guys know you can make some sort of argument to say that I have to conduct research as part of my role, right? We've been able to successfully even get product designers, these kinds of arguments related to research scholar, because there's something beautiful about innovative work or things that are on the front lines of what technology can look like over the next few years.
Okay, that's good to know. I still, it sounds like it may not apply to everyone on this call, but for those who are doing something innovative, something on the front line of the next breakthrough, or even playing a small part, they could make a case. Can you, let's say the J1 specialist program, sounds like that's easier to get because really I just have to show that I have specialized skill in something. Can I renew it after the first year?
So for the specialist, it's not like a true renewal. It's not like you can domestically extend it. What happens is that you would leave and you would essentially apply for the program again, right?
Okay.
Through the paperwork. But there's ways to preempt it. You can basically make sure that that new issuance occurs right before you leave, and then you go to the consulate and you come back.
Oh, it's not bad, but every year I have to keep doing that.
Right. For the specialists, because it's much more expansive, they do limit it. But for research scholars, it's 5 years. It's a long time.
And could I reapply after the 5 years for the research scholar?
So for the J1 research scholar, it's not renewable. It is just a 5-year ramp, but it is beneficial to say, hey, at least I don't have to do the lottery. You should know that this is more of like a plan B to give you that timeline in order to figure out an alternative solution or build up towards an O1, let's say.
Right. That makes sense. I think taking the really worst case scenario that the $100,000 fee would not go away, that it's going to impact people even within the country for applying. it sounds like the best alternatives are J1 and O1. And we will talk about the O1. So we just wait for that, guys. But J1, once again, I'm seeing a question from a LinkedIn user. Do we require any documentation to prove we are a specialist in the area? How does my job description differentiate me from a normal applicant versus a specialist?
So as much as we can express the job description for a J1 specialist, you would need to provide a resume, right? And your education. To be a specialist, you can say, I have a lot of experience in X, Y, and Z, right? Or I have like a really healthy amount of education in this particular field. Let's take, for example, a master's degree. But I've been able to even get this for somebody who doesn't even have a bachelor's degree. They had a lot of years of experience in Loom. That expansiveness of what defines a specialist is being able to show a level of expertise that's related to whatever work or skills that you will be providing here in the United States.
Okay. So it's some form of, I guess, another way to ask the question is documentation. Is that letter from my manager? Can I use salary as a form of showing it? And do I have to have a minimum salary to say I'm a specialist?
You don't need to have a minimum salary. The government basically wants to double check to make sure you can live appropriately in the United States and not be a public charge, so to speak. But in terms of documentation, of course, you can get letters from previous people that you've worked with to show that you have that work experience. But in terms of what you would ask from your employer would just need to certify and affirm that you're going to be providing them these special skills, or that they are going to be essentially your sponsor. It's just that they don't have to pay for it the same way that the H1B would require for it.
Okay, so the good news is minimum salary, the minimum wage that H1B imposes is not there for J1. So
yeah.
That's a good thing, right? Because I do think the H1B, they're also planning to increase the wage levels based on what's being said. Okay, that's good. To summarize the J1 again, J1 is a good option for people who can show that they're a specialist in their field in some way. And that's shown through like a degree, past work, letters from people. And what else am I missing? What else can you use to show a specialist?
You've hit the nail on the head. It's usually either education or experience, right? Or both. So that's usually both the
Gotcha.
way to do it.
Mm-hmm. So people who they think they have a specialized skill should look into the specialist program. Pros of the program: the bar is low. You can keep renewing it, or not renewing. You can keep applying every year. Essentially, you can do it for a long time. The con is that it only gives you 1 year. So it's not, ideal. On the other hand, the J1 research program, great thing, gives 5 years. You really don't have to worry about anything. But it is meant for people who are performing research as part of their job. And it's ideal for people who are not just researchers, but also working on cutting edge tech where they use research. Okay, last question on J1. I'm working at Amazon. Amazon is okay with getting me my J1. Who is the one actually applying for it? You said some agency. Who is this agency?
Right. So basically for every J1, there is this co-sponsoring agency. Think of it as like equivalent to a school. So you know how schools for F1, they issue all the paperwork, right? They give you your I-20 on all this kind of stuff. A co-sponsoring agency is an agency that essentially affirms that you are someone who's going to be safe in the United States. They usually are the ones that also provide you your health insurance. And they also check in to make sure that the company is actually hiring you and that you are truly, madly, deeply safe and healthy in the United States. They help maintain the program. The reason why they're called a co-sponsoring agency is because they issue that paperwork. They issue what is known as a DS 2019, DS 2019 that allows you to get this J1. And why they're called a co-sponsor is because your other sponsor is the employer, the one that's telling the government that, yes, I need this specialist, or yes, I need this research scholar here in the United States.
And these agencies, is it on me as the immigrant to go find the agency and get them to work with me and Amazon, or would Amazon take care of this?
So I could say that the onus or that the responsibility could be any of the three parties that usually would be involved in this kind of transaction, right? Could it be that you, as a foreign national, hired a lawyer to help you figure it out and then you present it to your employer? Or is it your employer or the attorney figured it out? Like, one of the three of us can be the ones to lead the charge.
Anyway, what you're saying is I don't have to worry too much about the agency part. Like, we'll figure it out. That's something that's not the hardest part of the J1. Is that right?
That is not the hardest part.
Alrighty. Now, I saw one question that I wanted to ask from Satabdi. Could you go from any non-immigrant visa to J1? Like, is there any restriction on from what visa I can go to a J1 from?
No, not really. The only thing that should be important to note for a lot of J1 programs is that they usually don't allow you to domestically change status in the US. So what does that mean? If I'm on an F1 and I want to go into the J1, you wouldn't be able to change your status from F1 to J1. And the weird thing is that the restriction is not from USCIS, because if you go online and you go to USCIS, they say you can change status to the J1. The restrictions usually come from the agencies themselves that issue the paperwork. But I've spoken to a lot of the largest agencies here in the United States that do J1 specialists and they do J1 research scholar programs, and they rarely have any denials. Again, it's very different from the J1 intern and trainee. I can see that. But there's a very big difference to approach a consulate and say, I'm a specialist, it's been certified as a specialist, or I'm a research scholar and I have a background in research, or I'm doing some really positive research for the United States.
Okay. Also, to everyone, guys, I put a list of J1 sponsors. So there's a website called Bridge USA. Is that the official website, Nicole, for J1?
It is the main website, but I would say the two largest institutions that do this, just so you guys are aware of it, is going to be CIEE and Cultural Vistas. Those are two of the largest institutions, and you can approach them. A lot of the times it can be helpful to have an attorney to kind of broker that relationship to make sure that everything runs smoothly throughout the process.
To repeat, that's CIEE and Cultural Vistas. I've put both links in the comment section. Please go read about that. All right. We are almost at time, but the O1 is actually a very important topic. So we'll extend by another 5 minutes just to make sure we cover this. A quick note to everyone listening. We'll do a webinar just on the O1 next month, I believe. So join that if you're interested in the O1. We'll talk in depth. For now, we're only going to do an overview and who should think about this. So O1. I'm on an O1 right now, Nicole, and I know the process inside and out. It's what I can say even before we kick this off is a lot of people come and ask me, hey, I have 1 year left. Do you think I can get the O1? And I say, it's not about can you or can you not. The O1 is meant for people who have contributed significantly to their fields. So it's a question of, do you think you can do everything possible to contribute a lot to the field that you say you're an expert in the next 12 months? So with that context, what is the O1 and who should think about applying?
So the O1, as is listed here, is an extraordinary ability visa, right? It rewards those who are arguably at the top of their fields. But the way that the government determines who is in the top of their field or determines like what should be granted is based on this criteria that they have listed. Now, I focused more on O1As because that's the predominant grouping here of individuals who are watching this webinar, but there is also an O1B for individuals who are in creative endeavors, whether it's motion pictures and television, or alternatively just general creative works like artists and performers and the like. But for the O1A, there's this 8 criteria, technically a hidden 9th if you want to talk about comparable evidence. And you need to meet at least 3 of those listed criteria. If you're able to meet 3 of the listed criteria, proving that you have sustained national or international acclaim, then you can get a visa that is valid for up to 3 years, and it is technically renewable. There's no cap. There's no limit to the number of these O1s that get issued per year, and there's no 6-year limit like the H1B. But to answer your question, Soundarya, on who should be considering this, right? My perspective, and maybe this is something that I think is very personal. I think, Soundarya, you and I have spoken to each other, especially at Open Atlas. I think we had like a great kind of discussion on this. I believe that everyone is capable of becoming extraordinary, right? I think that every single person, like if they really sit down and think themselves and they put the active energy and effort, right, to meet this criteria, it is possible to become extraordinary. And Soundarya hit the nail on the head. If you believe that within a 1 year time span, if you only have 1 year left, that you can effectively contribute to your particular field and prove these 3 criteria, then I don't see why not, right? And I will tell people that if you are thinking of investing your time, right, whether it's building into these criteria, maybe you already have 1, maybe you already have 2, just from looking at this list, right? What you need to determine to yourself is whether or not you're going to treat this like a second job, because I think you do.
Yeah.
You have your 9 to 5, you have, maybe whether it's more than that, I think a lot of us here work overtime, right? But you also need to be willing to put in all of that extra hours and effort into diligently building into these categories to really get to that point. But it is possible. We've seen it.
Yeah, it's kind of like asking, do you think I can get into Harvard? Do you think I can get into Stanford? Yeah. If you can show that you are worthy of getting into Harvard and Stanford, absolutely. So the O1 is very similar in the sense of, I truly believe everyone is capable of getting the O1 someday. That someday can be a year from now or 10 years from now. And that entirely depends on, it's kind of like an art and science, I think, Nicole, where you should really focus on contributing to your field. And also you should think of which of these contributions would directly help with the O1 at the same time. I'll give an example of this. I think one here is judging. Number 4, judging.
Right.
This, I would say, is something almost anyone can aim for. I don't know if they'll get it, but they can aim for it. Judging is about, for an engineer, it could be joining the panel for judging a hackathon or a pitch competition. The next time you come across an opportunity, now that you know this could help with the O1, you would probably sign up for it versus if you didn't know. So I feel like read about the criteria in depth or join the next month's webinar where we'll talk about this a lot, the O1 in more depth. But every single person on this call should, at the very least, go read about the O1 in depth after this. Just go read an article. If it helps, I'm going to post a link to a free guide that I published with another lawyer. It's part of my book, Unshackled. And we have broken down every single criteria with examples. So you can make use of that.
And just to add to that, I will note that at Manifest, we are setting up a series related to the O1. I think, Soundarya, you mentioned like next month, we're going to be doing a whole conversation, really deep diving into some of these categories and how you can develop into the right direction. I also want to let you guys know, for many of you who could qualify for this, Manifest does have an opportunity matching program. We do work with a lot of candidates to really get them into the right places or show them the right places that could be very beneficial to you developing your career or your future into a potential O1, right? Because for many of you who maybe are still on your F1 and you have time remaining, or many of you who maybe fall into those exceptions right now of the 3 areas that the H1B proclamation does not impact you in any way, I think it's a good time to really consider what your alternative plans are. Because if I could make one emphasis, especially to you, Soundarya, and to everyone that's here, the one thing that I took away from the press conference, like that public presentation with President Trump and with Stephen Lutnick when they first announced like this whole proclamation, right, is they repeatedly emphasized the wanting of, we don't mind bringing foreign workers to the US, but we want the top and the best of the talent. And they actually used the word extraordinary ability or extraordinary. And I do believe that word choice matters, right? And I'm curious to wonder, and I can only tell you that it's speculative at best, but I do think word choice does matter, right? If their mechanism or what they are trying to protect or what they want to further is the O1 visa, wouldn't it be a fantastic headline when they say, let us reorient or diminish the H1B, which isn't necessarily merit-based. It's necessarily people who win a lottery and there's a reasonable job offer being provided, right? And instead they say, look, we boosted the O1. Many people now who are extraordinary are coming to the United States. Like, here's our proof because of the number of extraordinary ability individuals now in the US, right? If you think about it from that perspective and that press conference that came out, I'm genuinely curious. Was that the game plan? Was that what they were thinking about at the moment?
Right. Yeah. I mean, I think for a lot of people, it's daunting. It's scary to look at the list of 8 criteria for the O1. It was for me the first time I saw it. I was just thinking, yeah, I don't know if I can do this. So for people who are thinking that, I can only say it's kind of, once again, like on day one, you're not qualified to get into Stanford and Harvard. But on day 365, you're probably 70% there. And so read the free guide, join the webinar next month, and in general, check out Manifest's other programs where they can help you with the O1. But I want to also briefly talk about the EB1A and NIW. Once again, we'll talk more in the O1 webinar about these other visas. Someone asked, can you guys explain the NIW if it can allow an applicant to sidestep the H1B process altogether? So I just want to quickly chime in that the EB1A and EB2 NIW are not work visas. They are simply petition to one day get a green card. Is that right, Nicole?
That is correct. It's like, let's call it you're buying a Q card, right? You're applying for a Q card towards a green card. Because like Turkish here mentioned, for the uninitiated, right? I wouldn't say the issue, but the thing about EB2 and NIWs and EB1As is that it's not usually an immediate process. It's not like you immediately get to sidestep anything. There could be backlogs that prevent you from filing the things that allow you to file, that allow you to stay in the United States. So I don't think it's that simplistic as being able to sidestep the whole entire process.
Exactly. I definitely. So whoever asked that question, once again, it does not let you work until you get the EAD card. And to get the EAD card, you have to actually file the second step in the process, which is the I-485. So go read about the process in depth. There's so many articles out there. And on that note, I'm also going to share a free guide on the NIW and EB1A that I wrote with my co-author. Oh, sorry. You can go read this as well. We made it very friendly, so you guys can easily understand what it means. All right. I think we're at the end of the webinar for now, Nicole. I'm also saying that the comment section has quieted down. I don't know if that's because people left or because people are just like, okay, what's happening right now?
I know. And I think
yeah.
I think what I was about to say is that it has to do with the fact that there isn't 100% clarity, right? And I genuinely do wish that I'm able to sit down here and tell you, if you have this situation, this is what's happening. If you have that situation, this is what's happening, right? I just think that if I had to draw a Venn diagram of everything that's happened, there's a tiny little middle of people who are completely exempted from this, and we've talked about it on this webinar, but then everybody else is kind of like in this disparate circles of like, do I qualify? Am I exempted? Yes or no? It just kind of depends on which process or which document you're reading at that moment. But yeah, I think that's the reason why we're not seeing a lot of questions or comments anymore, is because it's like, yeah, okay, so we need to wait and see. And I do genuinely believe that. I think even by the end of this week, we're going to know so much more than we did today, genuinely.
Yeah. And one advice I have for people, just as an immigrant, is I rarely open social media. I don't have it on my phone. I don't check it on my laptop. I just publish content that I think is useful, but I don't check social media. But the last 2 days, I was installing these apps and checking. Every single post was about this when I open Instagram and LinkedIn, because I do follow people in this area. I suspect for a lot of people watching, you're probably following many creators, lawyers, and people in general who talk about immigration and these topics. And I realize it's such a fatigue for me as a reader to see every single post talk about the same thing. So my recommendation is sign up for maybe 1 or 2 newsletters that are credible, that would give you the update as needed. Sign up for one person who will like publish about this as soon as it comes out, like one news publication that you trust. and just go off social media for some time. Like, really, you don't need to know everything that's happening all the time. You just need to know the latest next update on this. And that's just my advice as someone who doesn't use social media generally, but used it for the last 2 days and felt this, like, you can almost feel it in your body, this sense of nervousness and anxiety when you're always hearing about the news. I'm not sure if you have another comment there, Nicole.
Yeah, I think that there's like an immediate gut reaction to panic, and I totally understand that. I totally get that. I can only speak from myself. Like, I've been through this rodeo before, right? And it might have been a very different rodeo, but if you remember during the COVID pandemic, or a little bit before that, under Trump 1.0, they suddenly dropped the travel ban, right? Like, they were like, here's the list of 20 countries that all of a sudden cannot travel to the United States. And actually, when it was initially written, it was hard to interpret whether or not green card holders who were citizens of those countries were allowed to enter the United States, which would have been even more bonkers, right? We were getting frantic calls from people at the airport, and even CBP was super confused on how to apply all this stuff, right? This is not the first roller coaster ride that I've been through as a practitioner, as somebody who's been in this space. And all I can tell everybody is that as time progresses on, right, we will get more of that clarity, because at some point the government will have to explain, how are you going to do these payments? When are you going to do these payments, right? Who does it apply to and who it doesn't apply to, right? That will come out in some form or way.
Yeah. So once again, follow one or two credible lawyer/news publication for now, and just uninstall all the other apps, social media apps on your phone, and go do your job. Like, you're all talented people doing amazing work, I'm sure. Just focus on that for a while. Like, you'll get the news. It'll come to you through a WhatsApp group or a friend anyway, if it's very important. So that's my last comment. Nicole, are there other lawyers that you would recommend people follow? Who do you follow as an authority figure?
I would say, for a fact, like, I do follow Greg Siskind from Siskind Assessor. He's a bit of a scion in our industry. I do read his stuff. I will also say James Hollis. So James Hollis runs the consular update through factpattern.io. And essentially what he does is he provides a lot of great newsletters and updates about consular processing, which, to be honest, is a huge topic of conversation right now. So outside of everything that's happening with the H1B, with all of the requirements for an interview and no more interview waiver, I highly recommend subscribing to his newsletter as well. I can deeply respect it as a practitioner myself. Like, I do think Manifest does provide a lot of great content, but I'm not also somebody who's blind, because I do know that every firm or every practitioner out there could really provide really great updates that even I myself review.
Yeah. So Greg Siskind, James Hollis, and I just added Rajiv Khanna because I followed his work for a while, and I do think he publishes a lot of good content. So yeah, a few lawyers for you all to follow. And yes, hopefully you all have a more peaceful the next 2 days than the last 2 days. And we will launch another webinar. I will be doing another webinar next month, specifically on the O1. You know where my social media is, so you can follow there, and you'll be notified when we get closer to the date.
Sure. All right. So thank you, everyone, for having me. Thank you, Soundarya, for having me again. I know this is our second time working together on these kinds of calls, and I really appreciate you having me here.
Of course. Yeah, thanks for being conservative. I think it also gets people to think of worst case and start, being more proactive from now. At the very least, it'll make them more proactive. So thanks, everyone, for staying till here. I know we went over time. I expected to go over time, so I think we were just on time. Thank you so much.
Thanks, everyone. All right.